Good afternoon, everyone. Welcome to day 3 of our conference. Just a little bit of housekeeping today. You will have the program with various timings. Due to things that have changed over the past couple of days, we are going to keep the order in the program, but we have to change some of the timings. So we may actually get to our breakout rooms earlier than posted. And when we do get, after our first presentation is Dr. Rachel Birnbaum on the Integrated Domestic Violence Court. Then we will have a break. Then other court models, Sheila Early will be sharing her literature review. And then we'll go into Q&A with both Rachel and Sheila. We will then have another short break. And then when we go into the breakout room, there's a couple of STEM questions for us to consider in groups. But I will talk more about the breakout rooms later on when we actually get there. So we are going to begin with Dr. Rachel Birnbaum of King's University College at Western University, talking about the history of the Integrated Domestic Violence Court in Ontario. And Balbir, I believe that you have the technology.
Hello, everyone. My name is Rachel Birnbaum. Thank you very much for inviting me to your conference, particularly Balbir, who invited me. I'm going to be speaking about Ontario's Integrated Domestic Violence Court, opportunities and challenges. But first, I want to acknowledge, as a member of the King's faculty and the King's community, make a land acknowledgement that King's University College acknowledges that University College is situated on the traditional territories of the Anishinaabeg and Haudenosaunee, Lenape and Atawandran peoples, all of whom have long-standing relationships to the land of southwestern Ontario and the City of London. The First Nations communities of our local area include the Chippewas of the Thames First Nation, the Oneida Nation of the Thames, and the Munsee Delaware Nation. And in our region, there are 11 First Nation communities, as well as a growing Indigenous urban population. King's University College values the significant historical and contemporary contributions of local and regional First Nations and all the original peoples of the Turtle Island, also known as North America. I also want to acknowledge all the people. It not only took a village, it took a large village over the last 10 years with respect to putting this research project together. And these are just a few of the people that I want to particularly acknowledge. And again, if I left anybody out, I sincerely apologize, but it really did take a village to put this all together. Also with significant funding from the Department of Justice Canada and some smaller funding from SSHRC. So in the beginning, the court opened in June of 2011. Yes, long time ago. We initially had a community resource coordinator that was attached to the court, but sadly within a couple of years, we lost that coordinator, and I'll explain what some of the implications of that are. We got a family support worker program that was instituted by the Ministry of the Attorney General in 2011. So we had a worker from the Barbara Schleifer Clinic in particular, which is a women's assault program, who supported some of the women in this particular courthouse. On March the 16th in 2012, there was then made an automatic referral to IDVC. So the first month or so, it was voluntary, but we soon realized, actually the Chief Justice of Ontario realized that it really needed an automatic referral to the IDVC. So we had 2 dedicated family and criminal legal aid lawyers, which was extremely important, attached to this court, as well as a dedicated crown. In the background, there were a number of different committees. So there was an implementation committee, a community committee, an operations and a research subcommittee. All the stakeholder meetings were very broad and very inclusive. And the goals and objectives of the IDVC, similar to the ones in the United States and in other countries, is to have a one judge, one family model, to focus on victim safety, to focus on offender accountability, to streamline the court process, meaning that there are no conflicting court orders between the criminal and the family, and more importantly, to monitor these court orders. There were coordinated resources to assist children and families, and a better integration of involvement with all its community partners. And that was the goal and objectives from the beginning till today. So what cases are heard? In this particular court, there's summary convictions, which means that their criminal charges have to include assault causing bodily harm, and criminal harassment, or family claims that are about custody and access, child and spousal support, as well as a restraining order. So there were only 2 criminal courts in Toronto, the Old City Hall and College Park, with a corresponding 2 family courts at 47 Shepherd and 311, that we had someone, and originally it was the individual who we had sort of match these files together. And that's what's been a challenge right from the beginning, is being able to match the files from the criminal to the family, that it's the same, John Doe and Mary Doe that are being matched in these cases. So in terms of the research over the years, I've done 38 interviews, and the quantitative looked at 162 in the comparison group. So some of you would say, well, how could I have a comparison group? Well, there was no way to compare the IDVC to another IDVC. So what we did was we looked at the family court files one summer, where there were findings of where there were findings of criminal matters that were summary convictions, and then matched those files to create the comparison group of 162 versus 154 in the IDVC. And 2 papers with my colleagues have already been written. The first paper with Nick Balla and Peter Jaffe really was explaining what the court is, and how it got put together, and what and sort of the process that was going to go on from there. The second paper by myself, Dr. Saini, and Professor Balla really looked at only the quantitative outcomes with respect to how the court was doing, and now sort of finishing up a third paper that also incorporated some qualitative findings, which I'm going to present to you today. So some of the demographic data, it might come as a surprise, but the mother's average age was 33, father's about 37. You'll note that the income of these of the mothers and the fathers. This is a court that's situated sort of in downtown Toronto. And the vast majority of people that come here are not married necessarily, and have very low incomes, as well as not a lot of employment. The majority of the parents reported having only 1 child from the relationship, with their average age of 5 years of age. Initially, I was given ethics approval to be able to interview these children as long as they were 7 years of age or older. But as it turned out over the years, the vast majority of these children were under the age of 7, and I could not interview them. And then in retrospect, it would have been difficult to interview them in any event, given what the issues are. But I think it's important going forward that be another group of people, children, to hear what they have to say about these particular issues. The majority of the mothers obtained sole custody. There were some fathers that got sole custody, and then there was joint decision-making. And joint decision-making, what it was that the child still lives primarily with the mother, but both of the parents are making some of the major decisions about the child's care. And this is a bit of a table. You can see the differences in age. And, while they may be statistically significant, from a clinical perspective or substantive perspective, they're not all that significant. But you'll also see, even with respect to the income, very low income, which is extremely challenging in downtown Toronto, where it's extremely expensive to live. As I said, the number of children, the vast majority had 1. So which was pretty close to what the comparison group from the files that we found. Again, this is a discussion about a table about the comparison between the initial custody in the IDVC, the initial custody in the comparison group, and the final custody in both of these groups. And you can see that there is a significant change in the IDVC, particularly with the sole custody to the mother. Now, also, we looked at the number of times, how much involvement there was of the child welfare with respect to neglect allegations or concerns about, conflict in the relationship and how it was impacting children. And in the IDVC, there was 65% child welfare referrals being made, which doesn't necessarily then say that they actually took out action, but they perhaps were also monitoring the case versus 31%. In Ontario, as some of you may know, we have a very well organized supervised access network that's actually run by the Ministry of the Attorney General. And there are a number of not-for-profit agencies that run these, where parents can have visits with their children. And as you can probably guess, there was about 58% in the IDVC versus 25% in the comparison group, where one parent or the other had supervised access to their child. So let's look at some of the thematic findings. A lot of my research, or the research that I do with my colleagues, is very much mixed methods, because the statistics tell us one story, but hearing from the parents themselves certainly tell us another story that adds to those statistical findings. So I was able to interview 19 victims, all females, and 19 accused. 6 of those were females and 13 were males. And also a subsample of 6 of those were actually paired, of mothers and fathers, hearing what they had to say about the issues. So some of the questions, there were about 8 questions, and I wanted to ask them about their experience with the services. So whether that was with the family support worker, whether that was with child welfare, whether that was with the services at the courthouse for victims, victim services, you can see that the victims felt that they were found them very, very helpful. The Crown was very attuned to their needs. The other benefit is that it's a dedicated Crown, so it's not just different Crowns walking in, that they also started to hear what some of these issues are and were much more attuned to the victim. With respect to the accused, some of the men talked about no one's there to really help them. PARS, which is the Partner Assault program in Toronto, it changed from, I believe, 12 weeks to 8 weeks, or is it 16 weeks to 12 weeks during the course of the program. And there were a lot of issues that some of the men raised, and this one in particular, that one man said, he kept asking and there was no help to be found from some of these services. A lot of the victim services, though, are for female victims, and it is true that there are very few services for male victims, which is something that we also need to look at. And when a female is charged, there are few services such as PARS for females. There is some, but not as many as there could be. So another was looking at kind of the push and pull of the process. So the question had to deal more with what did you think about it? Were you heard, etc.? Was your voice heard in this process? And some of the victims said, the judge didn't always listen and talks more about to them as opposed to listening to them. Another said it was great, but enough was enough. A lot of the victims did feel that after a while, because again, this is a process of monitoring, and some of these cases, which is not unlike some of the findings that I found in other research from the US, is that the IDVC process takes longer actually than the comparison group. So some of these women did have enough. The accused, sort of the males felt that, they always took her side in terms of listening rather than hearing what I had to say, that it was fair, but not really. One said that they pled guilty to the charges. I mean, overall, the males, they took actually little responsibility, even though they were happy to have this integrated court, but they had it but the reasons sort of varied. So for women, it was about, you finally get to hear me and see me as a whole. And the accused, typically the males, would be talking more about, finally someone's going to hear me and know that I never did this. And there was very little sort of responsibility in any of the issues that were going on. Being heard by the judge was another question. Not really, but she heard me. Yes, it was good to get it out. There was a lot of, the vast majority of the female victims and some male victims, some male accused, I should say as well, really did feel heard by the judge. But as I said, there were different reasons of what it is that they were why they wanted to be heard. One accused female said the judge really listened to me as a whole person. And then one of the accused also said, I didn't do it. And that was the sort of ringing of what I kept hearing in the background, was a lack of responsibility with respect to anything that was going on, that they were feeling put upon by child welfare, or put upon by the police, etc. With respect to one of the victim and the accused partners, the male did plead guilty and there was joint custody. And I remember the female victim saying he's a far better father now than before. So while I said that, many of the men didn't take responsibility, there were quite a number of men that did, and actually learned from it and learned from the PARS program with respect to fathering and what it means to their children. The father in this case said, I learned a lot about myself through this process and now understand the impact on my kids. And these are the kinds of comments that you want to gather and sort of unpack, that you cannot find in gathering statistics alone. So a lot of people were saying, well, what are the stats? What are the stats? And I'm going, yes, there are stats, but you also have to listen to the voices of the parents who are really, sort of struggling with this and wanting some help and unpacking what some of these issues are. Another victim and accused, the male pled guilty and there was supervised access. The female victim said, I really felt heard by the judge and that everything is going well. And even the male who got the supervised access says, access is better with my children now because there are boundaries around what he can and cannot do, and that he's learning from this process as well. So what are some of the lessons learned from this? Well, the majority of the criminal matters were resolved by either being withdrawn, a suspended sentence, a peace bond, attending PARS or probation. There were, there were a number of criminal trials, and that's another sort of paper that I'm working on now with respect to looking at the criminal trials and what the outcomes are. They required more court days than what was anticipated. So, because it was a 3 to 4 court day, this particular court was only meeting twice a month. So trying to schedule these criminal trials over successive days was very difficult. There are no family trials to date that I'm aware of, but I stopped gathering data, I think it was in March of 2018, but they would also require more court days than anticipated. One of the other lessons was the sequencing of the criminal and the family case was challenging at times due to the adjournments that were required because the Crown needed to provide disclosure. Services were requested. If the judge ordered that the Office of the Children's Lawyer do a parenting assessment, that was going to take a few months. If child welfare was involved in a supportive way or an investigatory way, that took some time, and then reports had to get filed and then made its way back to this particular process. There were also some unintended consequences for the victims and the accused. And that had to do with based on more information sharing and one judge model. Having one judge see you over and over and over again you can't keep changing your story. And I do recall on one occasion where one father in the criminal matter, when it was being heard, so they'd hear the criminal matter of the case and then they would hear the family case. And you're standing in front of the same judge. And I'll never forget one of the fathers saying in the criminal matter, he didn't want the adjournment because it was impacting, and rightly so, on his work. He had to always take time off work to come to court to have to deal with the criminal matter and the family matter. And the judge was, listening to this and understanding that, that it does impact. And if he's not working, then he's not able to pay child support, etc. Then it came to the family matter, and the father stood up and he wanted to change his child support because he wasn't working as much. And I remember thinking, well, on the one hand, you're saying you don't want to lose any days. Then you're saying, it really was quite comical. And the judge kind of being sort of listening to both and trying to make a decision on these particular. So there's a lot of information sharing that's going on. And also the Crown is there more often than not, listening to the family matter as it unfolds and gathering information about the impact that it's having on the children and on the victim, because it is the Crown that makes the recommendation of whether the person, what type of, whether they're going to proceed, how they're going to proceed, whether it's going to be through PARS, through a peace bond, through probation, etc. So some of the court observations is the family in the criminal disputes is a changing narrative over time. So to say what are the outcomes, you have to be very clear on what it is that you're measuring, who the reporter is, and what is success and for whom. So even though the IDVC was taking longer, the judge was getting a better understanding of what the case was about. So there was a more holistic vision of looking at these particular cases than simply in a domestic violence court where the judge has no information about the family and no information about the individual in front of them. The majority of the males had legal representation for the criminal, not necessarily for the family. So while they felt that their rights they wanted their rights protected, so they would get a lawyer, even if it was a legal aid lawyer, in the family, they just felt like, well, I can do this on my own. The majority of the females had legal representation, and more often than not, it was through legal aid. There was also duty counsel available. So that's a lawyer that's available for the day for this particular issue, both for the complainant as well as for the accused. What I also saw were the family and criminal lawyers tended to remain very uncommunicative with one another and knew little about either case. The court was at 311 Jarvis, which is typically which is all family matters, except there are juvenile matters, youth criminal justice matters that go on in that court. And so the defense bar, who felt that it was, sort of a court that was too far away. They didn't want to deal with any of the family issues, sort of would fly into the court. They'd come in at that particular time for that day, but they knew very little about the family matter. The family lawyers, in another time when I was speaking with them in the first paper, felt that they had very little background about the criminal matter, and some actually thought that you had to be a family criminal lawyer to actually work with people in this court, and that's not the case. So even though there were a lot of meetings with the defense bar and the family bar, about what this court was about. You had to keep reminding them over and over again of the importance of hearing both matters fully. So what are some of the conclusions? Well, from information sharing does provide the Crown, the lawyers, and the judges with a more holistic understanding of what domestic violence and the family issues are all about. Another positive was the monitoring, the safety for the victims and the children, because as I said, the judge is monitoring the case from both perspectives all the way through. And there was flexibility and ease of change when the system and administrative issues needed to be identified. So if there was a referral to the PARS program, if the accused was in jail and required a holding cell, if bail conditions had to be done, typically in a domestic violence court only, it takes days and days and even months to get those changes made. These changes could be made literally on that day on the spot. So you can imagine what a relief that is, particularly to victims who then don't have to keep coming back. And if they have young children, you know, it's the cost of having someone look after their child, it's the cost of getting down to the courthouse, etc. But there are some challenges that do remain. It's the catchment area. So presently we have, as I said, it's a very narrow catchment area of only 2 criminal courts and 2 family courts that have all these individuals flowing in from to this court. And of course, I was always recommending that the catchment areas be broadened. And it's only in downtown Toronto, so it's not even available to the rest of Ontario. There still needs to be better integration and reporting to the court, whether that's through the Office of the Children's Lawyer, the supervised access services, child welfare services. There needs to be a better integration. There are fewer programs, as I said earlier, for females who are accused to be referred to, and fewer support services for males who are accused. So that needs to also be broadened a bit. And then lastly, sort of this lack of responsibility by males. One of the questions is, does that impact on safety issues for women? And with this constant monitoring, I think it limits that, but it's certainly something that the court does need to look at as it's going forward. So that is the Integrated Domestic Violence Court in Toronto. I think it's working. I think it's working well. It's a holistic perspective. Yes, it does come with challenges. But the court continues to work and monitor on that. So I thank you very much for listening to me, and I look forward to some of your questions and your comments. Thank you very much.
Thank you, Rachel. That was very informative, very clear, and I'm sure people will have questions or want to ask for more detail, perhaps later. We are going to take a 5-minute comfort break. So if everyone could return at 1:35 or stay in your seats, it's up to you. It's just sure that some people need to go grab a drink or whatever. So we'll start again. So Sheila, you'll be on at 1:35, please. You've seen, I don't know if you've seen in the chat, but Balbir has made arrangements for all the PowerPoints that have been used at this conference to be in the chat, and including a brief done by Justice Martinson and Professor Margaret Jackson on parenting assessments. So these, feel free to download them as we go along. And if you can't, for some technological reason, download them on the device that you're currently on, then you can contact Balbir in the future and she'll be able to provide them to you. So it's now my pleasure to introduce Sheila Early, who will, and is a very active NEVR member, who is going to give us an overview of some other models of courts that are available and that have been discussed in the literature. And Sheila, you have half an hour
And can you share a screen with me so I can use the slides then? Am I ready to go?
Do you need to share?
Yeah, I do.
So I think Balbir can make you co-host and you'll be able to share.
Is for individuals who have to testify in court when it is not their normal milieu. So what I have did is I reviewed literature through a number of searches, and I wanted to start with this particular saying: domestic violence cases are unique and therefore require a unique response. Next slide. I just also want to acknowledge that here in British Columbia, we are settlers on the land of the coast, Salish people, the Kwantlen, the Katazi, Semiahmoo, and Tsawwassen. And we also give them our gratitude for Turtle Island. Next slide. So this is what I did for research, and I've done research for books, etc., but I have not done one specifically on a topic that we knew that we're going to be using for other projects. So these are the search terms that I used, and I'm just going to list them there. You can read them, and you also have the PowerPoint. And these are the databases that I went through. I just named those for those who are not familiar with here in British Columbia. Kwantlen Polytech University, British Columbia Institute of Technology, Simon Fraser University, and UBC. It was a bit of a challenge because sometimes when I used integrated courts, what I got was database systems that were used for saving data in courts. So one hit got like 30,000 hits, and I'm thinking, oh no. But by the time I got through it, it was like maybe 15. So I reviewed the abstracts of 70 hits that I got. I did in-depth review 17 articles and documents, and one ebook which was 900 plus pages. I have another one that is 1,000 pages that I want to go through. This is from Canada, United States, Brazil, Australia, New Zealand, and of course the United Kingdom. Next slide. So what does the literature say? Okay. I'm doing a nutshell because I've got like 23 minutes to do this. These are the common features, from all the different readings, etc. So specialized staff in court time, coordination of information sharing, informed, consistent judicial decision making. That was one of the key things. Offender accountability, and you'll see a little bit later what that means. Victim safety, support and services, increased efficiency, training and education for all the disciplines involved in that particular court process, as well as evaluation. Of course, there were variations. In fact, I don't think I found more than 1 or 2 courts that were identical, and that was an odd thing. Even here in British Columbia, where we have several, they're different. One judge, one family was one way. Rotating judges was another, but within that specific integrated court. Some shared with many agencies, others only shared with a few. For example, one agency only shared with probation officers and community workers, and others shared with, Ministry of Children and Families, whatever is appropriate for your jurisdiction. Consistency was dependent still on the officials. So it didn't matter if it was one judge, one family. It still was not consistent throughout the duration of cases that came before that particular judge. Some courts necessitated that the accused had to plead guilty. That was the only way they could get into an integrated court. Some sort of services varied from location, particularly in the rural area. It was very difficult to find resources in a rural area, which limited resources both for the victim or the complainant and the accused. But also too, they might be the same services in a different way, like counseling, for example. Also, court time was saved. That came out through the literature. However, the number of court appearances did not always. So the individuals may have gone to court less time, but they still made appearances perhaps more. Excuse me. It also varied in how much financial support that each of these courts was provided. And again, evaluation is the key to knowing, as we just heard from Dr. Birnbaum, is that not all programs even underwent any kind of consistent evaluation. Sometimes they would have an initial evaluation after 1 year, 2 to 3 years of a project, and then go on. Okay, so that's kind of the highlights. So I'm going to discuss a couple more. I think there's maybe one back. AJ, I think we missed one slide, I think. Oh, no, sorry. Okay. No, sorry, my mistake. I thought there was another slide in there. Okay. So what I'm going to do now is go over some of the ones that I found that were key. And interestingly enough, I found that with such a variety, I wanted to start with this one, and it's British Columbia, where we are, and it is from 2014. This is from the Ministry of British Columbia Ministry of Justice, and it was called the Framework for Domestic Violence Courts in British Columbia. And I just wanted to highlight that this was done in 2014 and is now 2021, and that's 7 years ago. Just to keep that in mind for when we have discussions. So it had an anointed bibliography, which was really good at the time. Remember, we're 7 years back. It showed, discussed why DV courts should be developed or were being developed, what the different models were, the benefits and impacts and the challenges. It also detailed the framework for the key principles and critical components of DV court processes. The thing that I'm going to bring to your attention here is a statement that was at the very end of this particular document. While it is recognized that domestic violence court processes are but one option among the array of options for enhancing justice system responses to the issue of domestic violence, it is anticipated the interest of the community level in establishing specialized domestic courts will continue. I just leave it at that. Okay, so what it comes down to that there are two basic models when all things are said and done. The first one relies on what is called early intervention. And it says that it's basically designed for the people that are involved in a first-time offense, if you wish, where no serious harm has come to the victim. And this is usually where the individual has to plead guilty to be part of this integrated court. So they recognize that they have a problem. Perhaps there's drug or alcohol issues. Perhaps there's financial issues. Perhaps this is an immigrant family where having a hard time establishing their place in a new world after many years of traveling to come to Canada. It could also be hit by COVID, which affects all individuals, no matter where they live and what type of situation they are in financially, socially, and culturally. It also says that they agree to take responsibility. Okay, and the Yukon is as a court that is based on this model. And at the bottom, you'll see the references for whatever I'm using. The second one is there's what was called vigorous prosecution. So this is folks who come to the court more than once, who are high risk, repeat offenders, where there is sometimes grievous bodily harm, where there have been interventions that have not worked, and that this means that, or simply that this is so severe that it cannot be managed under the early intervention. This is usually when there's a criminal charge as well as the civil. The other thing that happens too is here that the accused may simply just not choose to plead guilty. And so that means that they have to have evidence put forward to prosecute this case. And the Toronto court is that one. Next slide. The next one that I really liked reading and was the Specialized Domestic Courts, Violence Courts in Canada and the US by Jennifer Koshin. And I found that this paper was very interesting in that it reviewed specialized domestic courts in Canada and the United States. And what it basically said is that there are certain advantages. It showed that there are used more than to promise to, sorry, I'm getting ahead of myself here. The DV courts were used to promote health and safety, et cetera, within the court system. However, it was found that sometimes they actually made it worse. And what this said is that it was putting children and families at risk. And it also discussed all the other weaknesses and strengths of those particular courts. What we did say is that factors that made these courts less successful were when they didn't prioritize women and safety for women and children's safety. So that was one of the key things that came out, that courts that seemed to put women and children first, or in some cases, men and children, that was one of the key things that was came out in evaluations. Next slide. The ebook, which is available and very, very interesting. I really liked this one. Jennifer Koshan, Janet Mosher, and Wanda Wagers. Basically, the summary on this one was every single province and territory laws were tabulated. And this is brand, well, new, it's 2020. So you could go through the book and you could easily see what each province and territory did according to every law that affected this, what we're talking about now. So for every law regarding children, every law regarding violence, it's court proceedings, probation orders, emergency orders, all those were detailed. And then you could go to links to actually find other documents that would assist you. So when you look at the cross-section of Canada, this is actually the one you want to look at. There's actually a very good glossary of legal terms as well. And it was very easy to compare one jurisdiction to another. I found an excellent reference that we can use when we discuss integrated courts as part of NEVR. Thank you. Go ahead. So little bits and tidbits of what I picked up from other ones. And again, limited to time, I found some interesting things. One was that Kuala Lumpur, which is the capital of Malaysia, uses a video conferencing technique so that the complainants and the accused can be in different locations. And this addresses the safety of women and children, or men and children, because there isn't the face-to-face contact, which seems to be the one of the very strong challenges we have in Canada when the complainant or the victim or the survivor, whatever word you choose, has to appear in court. And I know from being a nurse examiner, sitting in the courtroom knowing that the accused is staring at you and wondering what you're going to say about him or her. And there, it is very, very threatening. And you have to use all your skills as a professional to go through this and come out doing the expert job that you should. And for someone who doesn't have that experience, I really can say that I can't even imagine what it's like to appear in court in an intimate partner violence situation. Very, and being at separate locations would certainly help. Nang and Kagan from the United States talked about, in their article, talked about the arbitration process as being more preferred way of resolution of the incident at hand in integrated courts. So they very strongly promoted arbitration, which again has issues when the two people are presenting in front of a courtroom for some sort of resolution when they have not been able to get that resolution on their own. So how do you do that? And one of the things they commented on was the amount of resources that were available. So talking about outside counseling, outside professionals to assist. Ireland, on the other hand, is developing community courts with restorative justice as their goal. So they're saying that it is more important for restorative justice where to teach these individuals to get along, if you want, for want of a better term, in the circumstances of being parents or separated individuals. So there isn't any evaluation on that one yet because it was they're just doing that in 2019. And I also want to add in the document that just came out recently, well, actually April 2020, from West Coast Leaf. This is a toolkit for navigating section 276 and 278 in the criminal code. This is in part of the title. So this is actually around how to navigate it if you are the person that is involved in, from the complainant side of a court criminal process. And it is something that when I looked at it, it talks significantly about sexual violence, and we know that that's part of intimate partner violence, the physical component of it, which is often not alluded to in court cases. It's kind of what we've heard before from other presenters is don't talk about the violence because it's going to come back and bite you. However, what I found in this particular document was some really good references to violence-related trauma, to vicarious trauma, how to present things in a trauma-informed fashion. So that's one we should keep on our back burner when we move ahead. And next slide. Okay, I really wanted to end with this one because this is also very new, and it's also from British Columbia. It is May 2021, can't get newer than that. And it is also from RISE Legal Center, which we already heard Haley Hermrich talk about the previous document. This one is called, Are We Ready to Change? A Lawyer's Guide to Keeping Women and Children Safe in BC's Law System. And it's built on their previous research, which we heard about on day one. And it has a number of points that talk about how we need to move forward. We seem to be stuck in the middle of something that we haven't been able to address for a number of decades. When we go back to the 2014 document presented by the Ministry of Justice, you look here 7 years later and the same things are still happening. So have we really made progress? Perhaps a little, but not the kind of groundbreaking progress that we really do have to make. So the suggestions that I've highlighted from this document are two: guidance for lawyers from women survivors. And that's really interesting because what we all know now that boards of most kind within healthcare, for example, want to have clients, i.e. former patients, to be part of the mix in decision-making process. And this is an example of how the courts need to, whatever we go forward with, need to pay attention to those who have actually been through it. And also to listen to the ones who chose not to go through it because of consequences. So listen to survivors. And the survivor stories are really poignant. I mean, the first one that I, oops, lost my slide there. Okay, the first one that came up both in the previous document from RISE was, of course, the two children who were murdered by their father in Victoria on Christmas Eve. So that was a lead in, the buried children. Listen to survivors. It also detailed how to protect the victims. And again, this is with all regarding safety. Use a trauma-informed, violence-informed response. A simple word taken out of context really can challenge women, children, and men if they have to be on the side, were on the side of the complainant. One of the things that happens is that trauma-informed process has moved from various venues, particularly healthcare and community services against violence, that we all need to really be cognizant of what this means. And I don't think that's across the board yet. Minimize the gaps. The gaps were few and far between in some instances, but were huge in others. It basically said to lawyers, you know, you've got to pay attention to all these things. If your client says to you, I'm getting harassing phone calls, that's just one step. The next step may be stalking. The next step may be more violence. And I couldn't help but think of one particular situation when I was a nurse examiner where my patient actually chose to go through the court process, and I was not her primary caregiver, so I could have contact. The primary caregiver could not, for obvious reasons, for court. She called me and said, what do I do? He's running around my house with a machete outside, threatening to come in and kill me and the children. And I said, call the police. And she said, I have. He's gone by the time they get here. Anyway, it took a long bit of intervention, and actually Crown Counsel actually intervened. And the story for that particular woman was, not only was he running around outside her house at all hours of the night when people couldn't see him, threatening her and her children, but he also, the court services and MCFD said, if your children are being threatened, so you need to move out. And she couldn't afford to move. And her children were actually apprehended, which was one of the saddest cases I was involved in 13 years. There is a good outcome. She was able to get out of her house, get her children back, testify in court with dignity and respect, and move to another part of the country because she could not stay here. So that's the kind of thing that we don't want happening anymore. Here is a victim of sexual violence and her children are apprehended. So that minimizing the gaps, making sure those things don't happen. Also use intersectionality analysis of family violence. We all know that children are affected by violence, but we need to educate everyone else about how affected they are. And can an abuser be a good parent? Jury's out from my personal perspective, and that is my personal perspective. Be part of the ideological change. We're in the middle of a movement that has been building and building and building. And when I end this, the bottom line will be how I think what we need to do today is that it's time for a shift. And we need to gather all these forces and bring them together to say, now is the time. They also presented practical considerations for lawyers. So family violence screening. To get away from this, don't report the violence because it's going to come back and be negative for you. Safety planning, practical considerations. I mean, things like that, if you're not familiar from the lawyer's perspective, is where is your passport and do you have access to it? And it doesn't matter what culture or what race you're in. I know where my passport is and I know how to, that it's safe. Does everyone? Where are your children's birth certificates? Where's your marriage license? All those things. And where is a will if you happen to have one? Can you pack a bag and get out of the house in like 1 minute and 2 to 3 minutes? Or can you hide it somewhere at a relative, etc.? Could bring out considerably more safer practices so that you're not putting your client and her or his family at risk. We need to look at every single thing that we do within the court system and say, is it safe? Is it safe to have witnesses sit outside the courtroom until it's their turn to appear? Legislative gaps and strategic litigation. This one was a bit of an eye-opener for me because, and I know it's been alluded to through the conference, is how litigation is litigation, sorry. I left my brain at home this morning. Oh, I am home. Saying that, when there is a process where delay affects the whole court process and draws it out, causes more financial, more social, more psychological damage, then we need to figure out a way to put a stop to that. I mean, how many protection orders need to be generated? How many breaches of orders need to be done? And those are only the tip of the iceberg. So making sure that this is a way of ceding power away from the client and giving it to the accused. I want to end with this because this is actually from Are We Ready to Change? The time to make change is now. It has always been now. And what more fitting way to end this review of court processes? Thank you.
Well, Sheila, you covered an awful lot of material. Wonderful. Thank you for doing all that work for us. And no wonder you got a little bit mixed up, but because there was so much information. But that was great. Don't worry about that at all. I'd now like to invite Dr. Birnbaum to come back and to be with Sheila and to open up for questions and answers. So you have options. You can either stick your question in the chat or you can use your reactions to raise the little hand emoji. And it would be great if you could raise your hand emoji if you want to come in and ask it in person, because then I will be aware of you. At the moment, I've only got 25 people on a screen.
Oh, this is Sheila, and I just wanted to say thank you for those folks that are putting points in the chat. I really appreciate it. And I do have to say that there is so much work to be done. And I did tell Albir and Jen something in an email earlier. Yesterday, I had to leave the conference to go to another meeting, which was very involved. And the workings of that particular meeting made me realize so strongly the power of NEVR and its ability to listen to all the members with an equal voice and to break down the silos that this other meeting highly highlighted, and say that I can't be more proud to be a part of NEVR. I really mean that, because of the way it's being led and the fact that every one of us has the ability to contribute to bettering it. The time is now for integrated courts.
Thank you, Sheila. I'm not seeing any questions just yet, so I'm going to use chair's privilege and ask something that I'm interested in. Oh no, we have a question. I think this goes to both of you. What do you think the greatest challenge, barrier is to get governments to implement domestic violence courts? Our unit only deals with highest risk cases, and it's like pulling teeth to get one crown assigned to the case. I think that might be, Rachel, would you like to attempt this?
Sure. So again, I think what's important is that you have to distinguish between a domestic violence court that only hears domestic violence cases versus an integrated domestic violence court that hears family and criminal. And in Ontario, which I believe is the only one in Canada, is the only one that hears criminal and family, but that they are only cases where they're hybrid cases. So it's not, and I don't mean to say that one's worse than the other, but it's not, you're hearing murder cases that would go to a domestic violence court that would be handled differently. So in Ontario, as in many provinces, there's a dual relationship between the federal government and the provincial government of who does what. So in Ontario, this court is actually in the Ontario Court of Justice, which only hears family matters. But because the Chief Justice developed a rule, it was able to hear these criminal matters. But it becomes very complicated if you were to go to, also it's in British Columbia, sort of a higher court, because of this dual jurisdictional fight between the levels of government. This court started, as I said, in 2011. It started as a pilot. Now they don't use the word pilot anymore in 2021. It's pretty well, the word is gone, and it's just been moving along. And by the grace of goodness, it continues to move along. However, here in Ontario, they have built a one single criminal court in downtown Toronto. So all the domestic violence courts that were heard across Toronto are now going into one court. So does this mean that this integrated court will go into this criminal court, which does not hear family? And that's another challenge. So it is not easy from a structural point of view, from a legislative point of view. I would urge everyone to look at, there were 3 volumes that were put out by the Department of Justice on integrated criminal, child protection, and family matters. It's on their Department of Justice website. They're excellent, excellent documents to try to explain what some of the challenges are with respect to these different jurisdictions and how, how they all operate. We did have one case in the Superior Court where the Superior Court judge, said we need to do something about this, because when you're hearing domestic violence cases, you're hearing family cases. When you're hearing family cases, you're hearing domestic violence cases. You're hearing child protection cases. So, much like our crazy system of, health and wellness is in one ministry, and finances and is in another, like everything is siloed out, and everybody's got their own little fiefdom, and everyone's got their own pocket of money, And don't you dare touch my money, and don't you dare tell me how to run my little fiefdom. Government is not good at meeting the needs of people, generally speaking. Like they'll give you the money, but it's very hard to get them to look at the more holistic picture. So, while this court, integrated court, which is very, very different from a domestic violence court, has a lot of pluses, there are still a lot of challenges, because why should people in Oshawa, Ontario, or North Bay, Ontario, or Timmins, Ontario, which are the northern regions of Ontario, not get the same service as these people do in Toronto, Ontario? Why can't people in Edmonton or Vancouver get this kind of service? Because in the United States, and I did the literature review on the first paper, this is a no-brainer for the US. They may not do a lot of good things, but this they actually did quite well. It is a no-brainer of an integrated domestic violence court. Now, of course, it's difficult when it comes to evaluation because they throw in the kitchen sink. These courts, they have the same judge actually hearing the cases all the way through to trial, which I have a bit of difficulty with. Because then, you can't just all of a sudden change your hat after you've heard so much information. Here in Toronto, if it does go to trial, the criminal matter, it's heard by the other judge. So, there are all kinds of issues, but people have to distinguish between a domestic violence court, which again is great, I'm not saying it isn't, versus an integrated domestic violence court. And that we do not have a lot of in Canada. And to the best of my knowledge, as of today, is the only one that's in Toronto.
Thank you, Rachel. To go back to Mike's point, if anybody else has an answer, please feel free to join in. We have experts from all different sectors here in this virtual room.
Actually, Mike Darling's comment also too about pulling teeth, getting one assigned to a case. That is definitely one barrier, but the other part about it is preparing the actual case itself is an issue, because for example, specialized care provided to an individual when there has been physical violence has not been a priority for healthcare. So for example, the injuries that the individual may have need to be very clearly documented and photographed if possible, etc. So that when, because this court case could be, months or years down the road, and it needs to highlight what happened at the time of the incident. And if we had more information from healthcare about the physical aspects of violence and intimate partner violence, I think the courts would be better prepared to listen a little more. So it's simply not a court issue. It is violence is a healthcare issue as well. And that's where we need to bring that together. As far as the courts itself, my limited expertise on this is that, we have to go back and listen to what those who have been through it say, and work out all those fine details about protection. And also too, as Dr. Birnbaum says, very difficult to get that whole court case from beginning to end in one spot. It's something that we have to look at realistically, because do urban centers need one model and rural areas need another, perhaps?
Yeah, you raise a really important point that you have to listen to the victim. I mean, when I was listening to the excellent presentation yesterday by the RISE group that were reporting on, what these women were experiencing, many of the themes resonated with a lot of the victims that I spoke with, where the men were using it to advance their custody. There were the threats. Even though the court says that they hold them accountable, yes, but when they get to the PARS program, which has all kinds of issues, they don't accept that responsibility. And I often said to the judges, maybe you should be asking these people, what exactly did you learn in that PARS program? And hear what they have to say. So there was always, so, you know, I mean, I do the research in that court, but I did have a lot of discussions with the different groups about things that they needed to think about. But yeah, it really does, it really does resonate a lot of what was said yesterday with a lot of what the victims said in this court as well. But the vast majority found the services that were supportive for women were excellent. Victim witness services, family support services. I mean, the Barbara Schleifer Clinic does yeoman's work. Just absolutely, it's a women's legal clinic, and you know, does unbelievably excellent work, and was and is extremely supportive to a lot of these women. Their staff are incredibly sensitive, trained well, just, you know, regular human beings, even though some of them, no offense, are lawyers, but just very compassionate and caring and knowledgeable. And not all of them are lawyers though. So yeah, you really do have to listen to the victims. So, you know, and that's why I like doing multi-method research, you know, that yes, I have the stats to show things, but yes, you also needs to be bumped up with listening to the voices of both the victims and the accused, because the accused have a lot to say as well. You can't just tune them out because they're the accused. They had some significant issues that they wanted to share as well.
Thank you. And Rachel, I have a question for your research. I was quite surprised at the income level of the people involved here. And I'm wondering, is there any connection? Why was the court situated in that demographic? Do you have any information on that?
Well, it's a, you know, I mean, Toronto is a very expensive city to live. So it's a very urban area. A lot of these people don't own property. Like they're living in apartments. Many of them living, you know, in you know, many together in one apartment. So, and a lot of them don't have employment. If the vast majority are on legal aid certificates. So you have to be earning like practically in poverty of $8,000, $9,000, you know, which, you know, is absolutely absurd. So that's why the income level, and even in the comparison group, it was the same kind of income level. You know, every once in a while you might get somebody, you know, it would be, you know, sort of like an outlier of somebody making $100,000 or $150,000. But generally speaking, these are issues around poverty. So again, you need to think about how does poverty play into this as well when it comes to issues around domestic violence. And then now, while the court has been running during this COVID time and making us all crazy, and I'm sure, I mean, you know, we've been in Ontario, in Toronto, we've been, where I live, you know, we've been under lockdown since November of 2020. We're just slowly coming out of it. So the courts also have been in and out and on Zoom. And then, you know, there's a whole issue around technology and how do you hear people and all kinds of stuff. So it's been a significant challenge for people. There's no question. And context matters. You know, I believe what Sheila says, you know, domestic violence is a public health crisis. It is not a criminal issue. It is a public health crisis. But we continue to live in separate silos. Government refuses to see it. Now, for whatever reason, you know, mercifully, they're looking at it and integrating it when it comes to all the issues that have come out now with respect to the murdered and missing women's and the Indigenous issues. Like they're actually, like I hear the sounds of, yes, we have to integrate with health and education and this and that. And I'm going, yeah, so why can't you do this with the rest of all the issues as well? You know, I think it's great. So it's been a challenge. There's no question. It's been a challenge.
Thank you. Balbir, I see your hand.
Thank you, Jen. Rachel and Sheila, thank you very much for the very informative presentations. In terms of the income question, I thought it was quite interesting, Rachel, because we have done literature reviews, etc., when we wrote the book last year. And that's one of the correlations is income, low income and domestic violence. So I wasn't surprised that it was low income, but the amount of income I certainly was. The other question I have for both of you or any one of our very expert participants is there are different models. We do have Indigenous models that are out there, and restorative justice, as you are saying, and also our arbitration. And I'm wondering if you could describe them to participants so that they understand them when we go into discussions of what the differences are between them.
Sorry, the differences between
the restorative justice model, the Indigenous model, and also the arbitration model.
Yeah, I mean, it would be very difficult for me to speak to it from an IDVC perspective because that's not what this was about. Yeah. In general, they are very separate types of models. Equally, each has its pros and cons. You know, some might argue that in arbitration, there isn't an equal power with respect to men and women going in, and that somebody is arbitrating it, and it's typically will be, you know, women might be the losers in it. I've always firmly believed that women are better off in court than in arbitration or mediation. I don't think as much as we've done in Canada of training of mediators and arbitrators and working on, you know, domestic violence checklists, at least the government is right now. I still don't believe that it is really center mind when it's going on. The Divorce Act, which came into in March of this year. Well, as a child's, I'm very much pro child advocacy and child's rights, and it's front and center. It has a wonderful definition of family violence and coercive controlling, and it looks much similar to the BC legislation. But there's one problem. If you read the entire piece of legislation, it is very, in my opinion, very sort of almost like shared parenting language without using the word shared parenting. So maximum contact has been taken out, although some judges continue to interpret that legislation as maximum contact, but it is not in the legislation at all. We went through this with the Department of Justice and they know that it wasn't in there, but some judges continue to use it. I'm still not, in Ontario, I can only really speak about Ontario, I'm still not convinced that this new legislation has taken hold. So, you know, while there's some great work that was done on this legislation in British Columbia, I would have to probably concur that I think it's great that they have this new piece, but I don't know. I've been reading a lot of judgments, particularly where there's domestic violence allegations being raised in the materials. And I read the judgments and I really wonder how much credence was given to it, especially when there is no parenting assessment that was included with it because they're very expensive. Or, you know, how much, you know, like who has the best lawyer, who can speak the best. Sometimes that's what it comes down to. So, you know, I mean, I hope I'm proven wrong. I'm still waiting. So, but I can't really speak to the other two models because they're not, I'm not familiar with it. And it would be foolish of me to even try.
There are now 2 more questions in the chat. So when an ACC participates in the PAR program or any other program through the probation office, i.e. anger management, respectful relationships, is there any component of homework for them, or is it lecture format? Do they share their experiences in a group setting? So I assume this is for you, Rachel, as you mentioned the PAR program. Do you know?
Here in Ontario, it's a group format. You know, so that the men get together and talk about what the issues are. how they come to, how they come to taking any responsibility, or do they understand the charges? What are they going to do about it, etc. And there is a report that's written. And in the report, it'll state whether, they met the criteria or not. And that report is sent to the Crown, because that also helps the Crown decide, do we proceed to a trial? Do we negotiate a, plead guilty, but you have probation, or plead guilty, but you have X, Y, and Z? Yeah, and it's also given to the judge, for the judge to be aware of whether they complete it. Completing a program does not mean that you integrated the lessons learned. I mean, it's like any other kind of course that you take. You take the course, but it sometimes takes years till you integrate the information to be able to incorporate it and use it. I mean, when I graduated with a PhD in research, I wasn't this brilliant researcher the moment I graduated, and I'm still not this brilliant researcher, but it took years and years of practice and practice and practice and practice. So, this notion that, I took a course about my anger, and I hate the word anger management, because it's about power and control, not your anger. So what? An 8-week program, and all of a sudden I'm now cured? Like, I don't think so.
So I've got a question here from from Cecilia, and then I will come to you, Natalie. I see your hand. So Cecilia asks, I know Ontario IDVC is fairly new, but I was wondering if there are any indicators suggesting links between Ontario or other integrated courts and changes in recidivism rates. And if so, what aspects of integrated court may be facilitating this? Sheila, do you have any information on this from all your vast reading?
Well, the problem is that a lot of the programs don't do evaluations as detailed as Dr. Birnbaum's. So they don't always address recidivism rates. What I did find out is that it didn't work that well for serious or repeat offenders. Because once, if there was one incident and many moved on and there were no further incidents, and that's usually if they were part of an integrated domestic violence court. But in other circumstances, no, it did not. It wasn't fixed, if you want. The relationship still deteriorated, and there were offenses against the other individual. And it came down to a lot of the parenting issues. Things like trying to, one article I read basically talked about the individual who, because the mom did not want to be present when dad was with children, dad would antagonize the third party. And she said, I burnt through all my friends because they would be the ones to take the children to visit dad. And there were, threats, etc. And so that led to more and more court cases. So the bad thing is that each of the courts that were identified, the arbitration and the resolution, as well as the DV courts, because of the processes, you can't compare the recidivism. Mm-hmm. What would work? I don't know.
Yeah, I mean, recidivism is used as often, I mean, in the United States, a lot of the IDVC courts that had done an evaluation, and there are several. They're all government run, which is a whole other issue with respect to doing research, whether it's the government is evaluating it versus an independent researcher. So of their research, many of them did look at recidivism and then said, this is great because there was less, there was recidivism when they looked at these IDVC cases. I'm not so convinced because the court, they had different ways of measuring things right from the beginning. So what is it that I'm one of those very fussy people that you have to define what it is that you're measuring, and you're measuring apples to apples, not apples to oranges. And in many of these cases, they were literally measuring apples to oranges. So I'm not sure. We in the Toronto IDVC, even though this court has been going on since 2011, believe it or not, there's not a whole lot of cases. They come back from family because, of course, there's always something that goes on with children till they turn 18, and then they're still with you till they're 30. But there was not a lot of cases that came back. You know, there was one appeal, I remember. There was one fellow who did plead guilty, was found guilty. He came back, so you know that was. But there wasn't a whole lot, believe it or not. But I don't think recidivism is a good variable, like is a good proxy for how to measure these things. It's one of many variables that need to be examined.
Thank you. Natalie.
Yeah, I can't give exact numbers. Can you guys hear me okay?
Yes.
I'm a probation officer in Surrey, and I've been facilitating the program throughout my career in the past 14 years, RR Part 1. Also, because of the pandemic, it's become more of a condensed program being done through Zoom as well as through phone if needed, just because of the pandemic. So we even brought our programs to meet the needs of the offenders given the current situation. I can't give a specific number, but in my experience, I know that if people complete both parts of the program, there's a significant reduction in the rates of recidivism. And BC Corrections is an empirical based organization, and we have a whole research department, and they're constantly looking at the different rates and things like that. Also, in terms of our format, we do groups. They're anywhere from like probably average 10 to 15 men, I would say 10 to 12 on average. And they're men that are identified as high risk to reoffend. And I know there was a slide saying that, and I think it was Ontario, I may not be correct, that in some provinces, maybe in the Yukon or territories, that if someone's a first-time offender or lower risk, that they may not receive counseling. In British Columbia, our offenders who are moderate and high risk are eligible to do our core programs. However, that's up to the individual probation officer to make the determination. So when I get an offender, I have 60 days to complete my assessment. So if they're charged with domestic violence offense, so like a K file, sometimes the courts will not put the K on it, but after interviewing the offender, it may have been missed. If we realize it's a family, intimate violence partner relationship situation, we make it a K file. So that's part of our determination. Then we do the SARA risk assessment as well as the criminal risk needs assessment to determine their overall risk of reoffending. So in my practice, just because someone's a first-time offender would not mean that they're low risk. I'm not saying they are or are not, but somebody could be a first-time offender, and it could be, in terms of my research, in terms of reviewing police reports, talking to the victims, talking to the offender, this person could have had an extreme history of violence, which would increase their risk level. So first-time offender, for me, doesn't mean no counseling. It depends on their risk level. So that's just some of my experiences being a facilitator in BC.
So I've got one question, and I think then we have to move on with our agenda. And this is from Suki. I have noticed that when there are multiple DV files in a particular courtroom, it takes a while to see all the court updates in Justin because there is so much paperwork with DV files, a variance in conditions, SMT conditions. We don't typically see the court updates until after 4:35. Is this an issue with the DV courts in Toronto, or do they have more court workers assigned to that courtroom?
Interesting question. So first of all, it's the only courtroom that they share the same database. So there's always a problem between the criminal database and interfacing with the family database. So yes, sometimes there was a lag. So sometimes the judge who has the file in front of him or her hearing the matter doesn't have all the, unless they wrote copious notes from the 2 weeks before, may not have all the information. Even when the Crown comes in and brings his or her laptop and opens it up, sometimes because of technology, they can connect, sometimes they can't connect. And they're always trying to figure out getting updated. But that's one issue. The question that I think you're getting at, and correct me if I'm wrong, is that it just takes longer to hear. yeah, these cases do take longer to hear because the judge is not only case managing, but trying to help these people come to some kind of a resolution. So dealing with the criminal, then dealing with the family. And sometimes, yeah, the files are not up to date. And there was one particular victim that I spoke to that made that comment, that, you know, when she came to court, they didn't have it up to date. She knew because the Crown or victim witnesses got a hold of her and told her how it was going in the criminal side. So yeah, but this is these are the issues. These are the problems of the different databases. They are we still live in the 17th century. You know, while every province I hear and every territory, oh, we're changing the technology and it's getting better and better. No, it's not. They've still got these clunky systems that they're trying to sort out. And I fear with these Zoom calls, you know, the judges don't even have all the information in front of them when they're dealing with the individual cases. And, you know, the judges who are in the IDVC may not have all the information as well. We're talking about children's lives and women's lives. And it really does, you have to take a pause for a moment, how the system really is kind of unfolds, and particularly now, it's very concerning. You know, I mean, all of us could probably tell a horror story or two of what happened. You know, I mean, thank goodness there is yet to be anything, you know, which doesn't mean that that's great, that, you know, anything terrible happened on a case in an IDVC. But still, I always worry that there is a potential out there if we're not careful and more sensitive to all of this, particularly because these computer systems were never set up to talk to one another. Never.
So I would just like to say, Sheila and Rachel, thank you for some excellent presentations and what a vibrant question and answer. People are also commenting in the chat. The chat will be saved, of course. I'm now going to invite everybody to take a bit of a longer break and to come back at 2:50. So a chance for you to maybe go grab something to eat. But we're ahead of ourselves in the program. So let's just take these, come back at 2:50, and I will explain what we're going to be doing for the rest of the afternoon.
And I will bid you all good afternoon. It's about 20 to 6 here now.
Of course.
But I thank you very much for your kind invitation. I thank you all for for listening. And you all know where to find me if you want to get a hold of me. Not going anywhere. I'm still in lockdown.
Thank you.
Thank you, Rachel. Bye-bye.
Be well,
So
everybody.
we can stop recording until we come back at 2:50.
All right, it's 2:50.
Okay, we're at 2:50. Welcome back, everyone. This is where NEVR needs your input. As Balbir has explained already, we're going to be writing a report to give to policymakers to advise them on to how we see as an organization how to move forward on some of the issues that we've been discussing over the past 3 days. We're going to be going into individual groups. There'll be 10 groups, and each group will have a moderator, just so everybody remembers that they are a moderator. This is the list of moderators' names: Glossia, Balbir, myself, Ty, Corinne, Leslie, Cecilia, Lila, Kamaljit, and Sheila. So each room will have a moderator. So when AJ is allocating you to a room, it may take a moment or two because he has to make sure that there's only one moderator in each room. If you are a moderator and there's more than one of you in a room, decide who's staying. The other one exits the room and comes back to the main screen, and AJ will then reassign you. The first thing that will happen when your moderator is in the room is that the moderator will go down to the bottom of the bar and hit the record button. So each room will be recorded for us to be able to analyze later. However, the moderator will also be asking you, if you wish to speak, to raise your hand. Again, please use the little reaction emoji to do that so that they can see who wishes to talk. We'll be in the room for approximately half an hour. And the things that we want you to discuss is to list the pros and cons of the different models of courts that we've been discussing these past 3 days. And then halfway through, AJ will send a reminder to move on from that topic to discuss what is our wish list. If this was an ideal world, what would we wish for? Now, we'll, at the end of that time, we'll all come back together and we will ask for a report back. It may be that the moderator does the quick summary of what you've been discussing, or it may be one of you might want to volunteer. So bear with us while AJ moves us around. We're now going into groups. Okay, I'll rewind. Welcome back, everyone. That seemed to go very, very quickly. And now we're now moving into very brief feedback, because we are, as NEVR, going to collate all of this material. So we don't need extensive feedback, but just maybe 1 or 2 things that came out from your group. And I'm going to just start going down my moderators list and say, Glossia, you're up first. And please unmute.
Yes, hi. Sorry, I was here with my dog. So we were talking, we only had one person discussing. It was just me and her. So she was concerned about the integrated court system, having people to go to mediation and not having their rights take into account. Like it would go with the criminal justice system, with the criminal court and the family court. So that was a big concern. And if she had a suggestion, if we go to integrated court system, we need to be able to communicate pretty well and have all the files ready. Yeah, that's it.
Thank you. Moving on, Balbir.
I think I'm talking for our group. Hi, it's Hannah Barto here.
Great. Thank you, Hannah.
Yeah, so we went through a lot of the pros and the cons of the different models. I don't know that I have to review the cons of the current model. I think that's been made pretty apparent. And we did talk about one of the things we could potentially look at suggesting for future is, even if we're sticking with the same model, increasing the cultural sensitivity and decreasing the patriarchy that happens in the current model. We're bowing to judges and we're wearing robes and things like this, which is really a very white patriarchal colonial model. And we can get rid of do some minor things to change some of that, power differential and still show respect, I think. The integrated courts, I think there's a lot of pros, and I think that I'm probably preaching to the choir with a lot of them. Mostly that the 2 parties are probably likely more heard, that there's representation of both sides of the story, whereas with the current model, it seems like there's one story that gets picked apart rather than 2 separate stories that now we have to discuss and prove from a more objective situation. And then finally, with the integrated model, one of the pros is that women and children are considered together as a unit rather than as separate entities. Yeah, I'll leave it at that.
Thank you. Ty, just a couple of things that maybe haven't already been mentioned.
Some pros were differing sentences for such as like peace bonds for people who accepted responsibility for what they did. When groups can come together to make improvements in the relationship. Programs for females when they admit their use of violence. And yeah, those are the pros that we got.
Great, thank you. Corinne?
So for the pros, as Hannah has said, there's representation for the clients and getting their voices heard, although it can be a very long process. For the cons, it can be mentally draining for the clients who have to go through the court process. And as Haley mentioned yesterday, a lot of them have suffered from some sort of mental health issue.
Thank you. Leslie.
Hi. Yeah, we talked about that there needs to be more accountability in terms of programs that the abusers take in terms of going to counseling, that there should be some kind of way of showing that they are really learning. And on that same note, we thought there should be an anonymous way of asking questions in the NEVR conference, so that people could get more involved instead of just listening. We talked a lot about the comfort of the participants in terms of spending time in the courtroom together, spending time in the courthouse together, and that there should be private rooms. We talked about that there's no physical protection. I mean, there's sheriffs, but there's no door. You can't go behind a door generally and collect your thoughts without the other party being involved in your space. And we also talked about the problem with self-represented defendants going 6 or 8 months saying, I'm getting a lawyer, I'm getting a lawyer, I'm getting a lawyer, and then suddenly they're not eligible for legal aid, and then they represent themselves and re-traumatize the victim, and we found that to be problematic. One good thing about the integrated court system we found was the same judge.
Cecilia.
Okay, so I'm sorry, I'm just trying to read through my notes here because our two questions kind of got really blended. But as far as cons go, we pretty much discussed a lot of the things that have already been discussed, varying from the re-traumatization to the lack of communication between different models. I guess one thing we can add is that we also discussed.
I think you need to unmute, Kamaljit.
That's another challenge. Okay, so we basically discussed almost the same things, but actually apart from that, there is we talked about the separated specialized courtrooms for special cases such as domestic violence. Secondly, we realized that actually the witnesses are not safe, so the statements can be taken through Zoom or in a more safe kind of environment. Another thing we talked about is that actually the lawyers are not sometimes very insensitive, and they are putting men and women in the same room where it's not safe for them. Culturally, sensitivity is very much required.
Thank you. Sheila. You're muted, Sheila.
I forgot the question.
Sheila, we just need you to report back on what your group discussed.
I'm sorry, I think that's me.
Oh, Hannah.
I'm hearing Sheila thinking, oh, that's me, yes. So in terms of our,
we already reported on our group, Jen, we were.
Okay, understood.
Yeah, that's why I'm kind of staring off into space, because I'm thinking I already reported on this. And
okay.
And I'm thinking, didn't we do that? Or, what else do I need to add?
Look, it's COVID brain and it's the end of a 3-day conference. I'm unraveling here. So anyway, I'm fine really. Our group volunteered me to report. Basically, we found that that there are problems with family court for high-risk offenders getting access to their kids and the use of family court material in criminal court by the offender. And the fact that the criminal court does not provide safety for victims and can also teach offenders that they can breach orders, and then they think that they can they can continue to breach in family court as well. And it was the opinion that all 3 of those problems of the criminal court system would be reduced by an integrated court system. but that integrated court system needs to recognise that support workers need to be paid. We also recognise the same problems Rachel raised with integrated courts, in that there's some sequencing difficulties, litigation drag, lack of communication between lawyers. Our wish list, in no particular order, is we need translators, we need the voices of children to be heard in whichever system. There needs to be not just integrated court, but more integration across services, across police departments. In other words, ditch the silos. It was explained to us that sometimes in Canada, you have the case at the Crown will not pick up a case of domestic violence if the victim can't speak well, or refuses to speak, whereas in the United States, victims are not required to give testimony, as they can, the police can pursue using other evidence to prove that a violent incident had occurred. And so that might be useful here. We also talked about Zoom or other such things. And we finished up by saying we need more awareness amongst police and service providers of men as victims. And I would add, lastly, we also need to be aware that people of sexual and gender minorities might not benefit from a one-size-fits-all people, in the same way that Indigenous folks might not benefit from it. And so we're back to our cultural awareness and safety needs to include sexual and gender minorities. And that concludes our reporting back. Now, whilst we were doing that, Balbir put into the chat, you may have to go back up, the post-conference survey. And we would really like it if you could follow that link now and do the survey, assessing what you now know about the things you were asked about pre-conference. You'll need your 4-digit the code number that you created. Yeah, 4 letters, 4 numbers. So you'll need that to be able to go in, so that allows us to link your pre and post, so we can see it's anonymous, but we can see how much learning was there. And I understand that once you've done that survey, there is a link to basically a raffle to win an iPad. So we're trying to incentivize you by inviting you to do it now in the last 10 minutes or so of the conference. And then Balbir will give her closing remarks. So take some conference time, go fill out your survey.
And also someone had asked about the certificate. I have put it in the chat. Just put your name in there, and I've already signed them, so you're good.
Leslie's saying hi, Sylvie, so good to see you.
Jennifer, I just wanted to make one comment.
Absolutely. Who's speaking?
It's Suki. Yeah. One of the things I'm noticing with my domestic files is to do with immigration. When we get individuals coming and being part of the criminal justice system because they're on a work permit or student visa, they're getting conditional discharges or peace bonds. So it doesn't look like any sort of conviction, so that they don't get taken back to their place, deported back to their country because of immigration issues. And I'm seeing a little bit of rise in these type of files showing up. And my concern would be sooner or later, the public wondering, okay, are we really addressing this as a criminal, criminal case, or are we addressing this as an immigration case? So let's give the accused person certain conditions so it doesn't go down on his record. So if there's a high domestic, I really have concerns later on as to how often is this going to be dealt with a conditional discharge.
Thanks for raising that, Suki. Does anybody have a response or have made a similar observation? Sorry for the background sirens. I have sirens going off on Highway 10 and the dog howling next to them. Albira, I see your hand.
Yeah, I don't necessarily have an answer for you, Suki, other than I know the changes were made around actually so that the survivor wouldn't fear being deported. And so maybe that's an unintentional consequence of that. But what we can do is invite our member Kamaljit Lehal, who's was a part of getting that legislative change through, to come and talk to us about it, and she'll have more insights into it.
Okay.
We can do that. We can invite her to a regular NEVR meeting, which can take place quite quickly. And anybody is free to join those. And as we're having those this way at the moment, then hopefully that will increase people's ability to attend. So I'm now going to assume that you filled out your survey and say thank you, and invite Balbir to give her closing remarks.
Sure. What informative and thought-provoking 3 days. I mean, I want to thank all the speakers and all of you who participated, and of course, Jen for emceeing, our conference committee for helping put it together. It will really inform our report in terms of what we put forward to different stakeholders. And this isn't the end of it. This is actually just the beginning. I'm suspecting, because I'm hearing throughout the conference, that we're going to find similar things to what we said in 2011. It doesn't seem like much has changed. A little bit has changed, but not very much. And so when we put the report together, I would really appreciate it if all of you would then read it and make sure it's accurate, and that anything you wanted included, if it's not there, you can let me know. And also the survey, that if you haven't done it yet, when you do it, also ask you questions so that we can include different perspectives as we're writing. So after the report is written, like I said, we will get it back out to you. We'll recollect feedback and finalize the report. And then if we have consensus on what people are saying or the top priorities, then that is the change we will push for. I don't guarantee it'll be integrated courts, because I don't know what everybody is saying, but it was integrated courts in 2011. People were really wanting them at that time. And we did hear from Rachel about our only integrated court in Canada, and she is correct, because I've done the literature review as well. And that legislative glitch about federal and provincial jurisdiction is the reason the last government wouldn't do it when we lobbied them last time around. So that will still be a challenge, and then we'll have to figure out ways of how do we get around that. But if anybody knows the Chief Justice, that's the person that can make the difference. So just giving you a warning in terms of where that would go. But other than that, I think it's been a wonderful conference. I invite you all to the NEVR meeting. If you're not already on our list, please email never@kpu.ca. And we will get you included in our list so you are aware. The meetings are where we bring new knowledge, new articles, new books, anything we may have read to inform all of us together. And we invite you to do the same, as well as talk about what are your challenges, or what are your programs that seem to be working really well, so we can share them and have others doing it. And as far as NEVR is concerned, from the academic perspective, we usually have students. So if you have projects that you want done, or literature reviews you need, or you need evaluation help, we usually have students that can help you. And as well, some of the academics on the committee can help you too. So that's it in a nutshell. Thank you very much again for attending. Without your participation, NEVR does not exist.
Thank you, Balbir. Can I just say to all those who moderated, thank you so much. And those recordings that you made will be on your system.